Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. Tonight, putting my master's in cybersecurity law to good use. We're talking about the new FTC Safeguards Rule. And from my experience, I do not think companies are taking this seriously enough. So I wanted to make this video to talk about some of the finer points here, but also emphasize how important and how strenuous it will be to comply with this law, and probably how strenuously the FTC is going to enforce this law. All right, so let's go ahead and jump on into it. First things first, I am not your attorney. I am just an insurance guy. All right, so please talk to your attorney. All right, now the Safeguards Rule. Number one, many more businesses are going to fall under this rule, but they don't yet realize it. Next, the requirements here are not a checklist. This is not, hey, MSP, here are the things we have to do. Just make it happen. No, there's way more to it than that. And frankly, there's no way an MSP could, fulfill all of these requirements for a client just on their own. Next, MSPs are not the fall guy. There is specific publication put out by the FTC effectively emphasizing this point. Enforcement is brutal and can be very personal. We're going to get into that. And I'll show your potential clients there, hey, this is how serious this could be if you run afoul of the FTC and the new Safeguards Rule. Next, cyber insurance probably not going to pay for all the fallout that occurs with an FTC consent order. And then, of course, interpretations are going to change. So without delving too deep into administrative law, this is only the beginning. All right, so let's start off. Who is actually supposed to adhere to this rule? And the short answer is financial institutions. The longer answer is an entity is a financial institution if it's engaged in an activity that is financial in nature or is incidental to such activities. And that incidental part is the key. So, greater clarification from the FTC here. Consider that the rule defines financial institution in a way that's broader than how people may use that phrase in conversation. Furthermore, and this is a direct quote from the FTC, what matters are the types of activities your business undertakes, not how you or others categorize your company. So I would argue here, as we go through this, businesses out there really just need to go to an attorney and say, hey, do you think I need to comply with this rule given the myriad of inputs that the client would have to give their attorney? Now, here are some concrete examples, but this is not an exhaustive list. All right, it is not just only these companies have to adhere to it. It's here are specific examples of companies that have to adhere to it. All right, so mortgage lenders, payday lenders, finance companies, mortgage brokers, account servicers, check cashers, wire transferers. If anybody knows precisely what a wire transferer is, please let me know. I wasn't really able to track that down. It kind of came across some conflicting information. So if you know, please comment that down below. Collection agencies, credit counselors, and other financial advisors, tax preparation firms. So pretty much like every CPA firm out there is going to have to deal with this. Non-federally insured credit unions and investment advisors that aren't required to register with the SEC. So for you RIAs out there that don't yet meet, I think it's 110 million AUM, you're playing by state rules, well, you might have some more on your plate now. Also, new category here, finders, and that's someone who brings together a buyer and a seller, then the two parties finish the transaction. So in my mind, that's M&A brokers, so mergers and acquisitions brokers, but I could be wrong. So see if you're a finder. And then also they expand it. A retailer extending credit, auto dealerships that lease vehicles. There was a famous case about that a few years ago. A real estate appraiser, a career counselor in financial services, a business that prints checks for consumers, very specific. A business that regularly wires money to and from consumers. Now, what does that mean? I'm sure that's going to be litigated on what the term regularly means. They did not, as far as I could find, have any hard and fast rule of X number of times per month or a total of X number of wire transfers per year. It just says regularly wires to and from consumers. So if it's once a month, is that regularly? Is it once a week? Is it once a day? Is it more than that? I have no idea. So that's why legal counsel needs to get involved with this to help the clients understand what does it mean to regularly wire money to and from consumers. And then a travel agency in connection with financial services. All right, who is wholly exempt? Those under the CFTC, FAMC. If you know what those are, then you know what I'm talking about. If you don't know what those are, then you probably don't have anything to worry about. Other certain institutions chartered by Congress. I'm sure there's a bunch of trade groups out there that had a bunch of input on this. And then more specifically, once again, this is why you have to get an attorney or your clients need an attorney. Entities that engage in financial activities, but that are not significantly engaged in those financial activities, and entities that engage in activities incidental to financial activities, but that are not significantly engaged in activities incidental to financial services. What in the hell does that mean? I have no idea. That means people need to go to their attorneys and get a qualified legal opinion on if they need to engage with this, because it's so obtuse the way that this was worded. They are trying, as with any administrative law, they are trying to cast the net as wide as the law will possibly allow them. And then maybe they'll narrow it down, but I wouldn't want to be the company that tests whether I should have actually been under the Safeguards Rule and I wasn't complying, because then you're in a world of hurt by that point. All right, what are you safeguarding? Nothing crazy here. Customer information means any record containing non-public personal information about a consumer of a financial institution. Now, the interesting part here is whether in paper, electronic, or other form. So just because somebody has a bunch of files, it doesn't mean they're exempt from this. And you're going to see a little bit later on, this requires administrative, physical, and technical safeguards. All right, so all the way down to, are you, for example, conducting background checks on the cleaning service that comes into your office because you're a CPA firm? It could get that granular, all right? And it's handled or maintained by or on behalf of you or your affiliates. So just because some other guy's storing it, once again, this gets into data holder versus data owner. Just because someone else is holding it doesn't mean that your business is not going to be responsible for this information. And then non-public personal information, kind of the nested definition there, personally identifiable financial information. All right, how do you safeguard that data? And this is where it really starts getting interesting. All right, what is it you effectively have to do? You have to have a written information security program appropriate to the size and complexity of your business, your activities, and the information you hold. So what does that mean? That means there are no standard templates, all right, outside of maybe mapping to the NIST cybersecurity framework and going from there. That means you can't just, if you have a buddy in the town over, he runs a similar business, he's got a written information security program, you can't just slap your name on it and call it a day. All right, it's going to be hyper specific to your exact business. Next, it must encompass, as I said before, administrative, physical, and technical safeguards. So they're looking at this from every single angle. All right, don't be the guy that has a bunch of stuff fall off the back of a truck and now you have to deal with the FTC consent order. All of this boils down to the program must be reasonable. Now, I put a definition in here from Cornell Law School. The reasonable person standard is the standard of care that a reasonably prudent person would observe under a given set of circumstances. Now, this whole reasonable person standard, this is like the bane of every first-year law school student. The way I like to explain it to people when I'm talking about the FTC Safeguards Rule is the following scenario. Let's imagine you are at the wrong end of a very long table And at the other end of the table are a bunch of government bureaucrats that are trying to set a standard. They're trying to get promoted. They're trying to make a point. And literally their boss prints money. All right. They may have never actually worked in the real world. So imagine you would have to go through the entire NIST cybersecurity framework line by line and explain to them why you did or did not implement specific controls and why those weren't checked. And if they were checked, how were they checked, et cetera, et cetera. You can see how that would be an excruciatingly painful process. So if you get nothing else out of this video, yes, you're going to be paying more for cybersecurity. No, there's probably nothing you can do about it. Blame the government. All right, vote for somebody else. That's all we can say here. All right, continuing on. You have to designate a qualified individual to implement and supervise the security program. We're going to be doing a little bit deeper dive on this moving forward. Next, there are exemptions for some of these. All right, so the exemptions would be if you have under 5,000 consumer records. That's not that much. Then the exemptions may apply to you. Talk to legal counsel. Implement and review access controls, inventory data and devices, encrypt customer information while resting and in transit, assess the security of your applications, implement MFA for anyone accessing customer information. So what happens if you are outsourcing part of your business overseas? This was actually a case that was already dealt with many, many years ago. They have to abide by the same controls that you do, right? To take care of that customer information. Ergo, if you're a CPA firm and you are outsourcing client data to India for tax return purposes, right? You got outsourced workforce over there. They're going to have MFA to access your customer information. All right. So logistically, you might as well just start taking care of it now. All right. But there's more. There's more to this. One, disposing of customer info securely after 2 years unless needed. Now, there's some extra caveats to this, but now we have to start thinking deeper, right? So we have to go, okay, paper records, copiers, multifunction printers that may have some type of memory on them or some type of hard drive. What's your business doing to ensure that once that multifunction printer goes out the door, right, you bought a new one, the copier dealer came in, took care of it. Where's that information going? Because you could still be held legally liable for that. Next, anticipate and evaluate changes to your system or network. Your safeguards can't be static. And that's directly from the FTC. Your safeguards cannot be static. So once again, if you fall under the FTC Safeguards Rule, yes, you are going to be spending more money on cybersecurity. There's pretty much nothing you can do about it. Also, you're going to have to keep tabs on, hey, what are the latest threats out there? What are the changes to my network? Is my business growing? Is my business shrinking? Am I moving into new areas? How do we need additional controls, effectively additional controls to try and safeguard that in accordance with this law? All right. I will talk about a POI. That's a plan of implementation. Next, a log of authorized and unauthorized user access, continuous monitoring, or annual penetration testing and vulnerability assessments, including system-wide scans every 6 months. Security awareness training for employees is now just mandatory. No exceptions there. I will add, if you think you're going to get away with once a year security awareness training because you're like, hey, I'm going to check that box. Like if I said before, this is not a checklist. So would those government bureaucrats at the other end of that very long table say, well, why weren't you doing security awareness training every month? That would be reasonable given the type of information you have, not just once a year. So keep this in mind. All right. Also, pragmatically, you need to do it more than once a year. Next, monitor service providers. So an example of all of this, a lot of this really kind of sounds like the quarterly business review that you could have with an MSP. Create a written incident response plan, which includes a process to fix any identified weaknesses in your systems and controls. So here, once again, the guys at the other end of the table, their boss prints money. Your business does not have unlimited money. So in that regard, highly recommend for a bunch of other purposes as well, you implement a plan of implementation. All right, so get with your MSP, and with that, be like, hey, what's the biggest bang for the buck? What are the biggest weaknesses we have? All right, we don't have an unlimited budget. Let's put together a plan of implementation so that we can start trying to chip away at this. All right. In that vein, I would say that's probably going to go a long way in your defense. If you do get hit, regulators start coming, you have a class action claim against you, right? The idea there is hopefully you can sit there and go, hey, we understand we got hit. We're very, very sorry. We understand that our network wasn't perfect. We had this plan of implementation. We sat down with our MSP. We sat down with the CFO and the CEO and the CIO and all these people. We signed off on it. We were chipping away at it. It just roll the dice. We got the bad luck. All right. So hopefully that can be part of your defense. Now let's talk about that qualified individual, because I would imagine there are going to be all types of misconceptions. I've seen them already out there. So even if you have under 5,000 consumer records, it looks like you still have to appoint a qualified individual to oversee the program. Now remember, that program includes administrative, physical, and technical safeguards. So it's dubious whether, in my mind, an MSP could actually maintain the program, because if you're just a business, what do they know about the physical safeguards you have? What do they know about the administrative controls you have around wiring money, right? If you need two-person integrity, prearranged callback number, known person, all that kind of stuff, that's just not really in their purview. But if you have over 5,000 consumer records, this qualified individual must report the overall status of the InfoSec program and your compliance status, address the risk assessment, risk management, control decisions, service provider arrangements, results of testing, security events or violation, and management's response and recommended changes. That sounds a hell of a lot like an in-depth quarterly or business review with an MSP, right? Where they're saying, hey, this is what happened. This is where we're going. This is stuff that's going to be out of date. This is where we recommend we move forward with additional controls. So you might want to start taking those a little more seriously. Now, the FTC has explicitly put out guidance on the fact that your service providers are not going to be the fall guys if the FTC comes knocking on your door or some other government agency. Because, directly from the FTC, if your company brings in a service provider to implement and supervise your program, the buck stops with you. It's your company's responsibility to designate a senior employee to supervise that person. And I'm pretty sure I know exactly why they put the senior employee in a supervisory status in there. I'm going to show you that here in a sec because it is terrifying. So that guy may need a raise. If the qualified individual works for an affiliate or service provider, that affiliate or service provider must also maintain an information security program that protects your business. Now, what does the word maintain mean? And I hate to sound pedantic, but let's say you wanted your MSP to be the qualified individual. Well, they have to maintain the information security program, which includes administrative, physical, and technical safeguards. They can obviously fulfill a third of that requirement. The other two I'm really dubious about. So I'm not entirely sure like how feasible it is even to make the MSP the qualified individual. All right. So my assumption, I think most businesses, probably the qualified individual is going to be within the company, not within the MSP, if I had to put my money on it, because it just doesn't make sense to try and push it over to an MSP. Now you have to be communicating every single change to the program, to the MSP. They have to update their documents over there, keep tabs on it. That doesn't make that much sense to me. Maybe there's a way that I'm not thinking about right now that will become very, very clear in a month and I'll eat my hat. But for the time being, I just don't see it. So, right, they must maintain the program. administrative, physical, and technical safeguards. All right, now let's get into the, well, there's no carrot. It's just all stick, unfortunately. Enforcement. There's 8 different federal agencies that can enforce this rule. Could deal with one company enforcement. If you don't believe me, there's the entire list. That's the URL. Go to it, check it out. And individual enforcement. So remember that person that was supposed to supervise the qualified individual? That's where I think this is going to get awfully spicy. So first, let's go with company enforcement. And I wanted to dispel a rumor here. So, we see a lot of, the FTC went after Facebook, the FTC went after, or Meta or whatever. FTC went after Chegg, FTC went after this other big company and this other behemoth company. So they only go after behemoth companies. Not true. So I wanted to point out in the matter of Gregory Navone, this is an old case, been around a really, really long time. The FTC went after this guy. And it says by the time of the FTC action, most of his companies were either no longer operational or were being operated by somebody else. So this guy was like effectively retired. He's a solo guy. And if I'm remembering this correctly, and don't quote me on this, I'm pretty sure he just had a bunch of documents in boxes like in his garage. All right. And the FTC still went after this guy. So if you are bigger than one person, the FTC can and will come after you if they see fit. Now, if the FTC comes after you, what's going to happen? A 20-year consent order. And I would just argue, I say this all the time, you're going to increase your cybersecurity, but there's only 2 ways it's going to happen. It's going to be the easy way or it's going to be the hard way. Highly recommend you go the easy way. Here's an example of the hard way. And this was, you're not meant to read all that. I highlighted all the additional controls that now have to be implemented and attested to with various third parties at specific intervals. But here we go. Create a written information security program, essentially create a chief information security officer, risk assessments, document retention and destruction, code reviews, penetration testing, input validations, network segmentation, IPDS implementation, file integrity monitoring tools, DLPs, location upload restrictions, encryption of PII, vulnerability testing, service provider selection, yearly certification to the FTC, and there's some other stuff. It's like once a year, once every 2 years. I think there's one over there every 6 months. Various compliance reports where you got to bring in somebody, and I believe they have to have like specific credentials involved, so that's a nightmare. Accounting record issues, employee training, and once again, for 20 years. All right, now imagine how much that would cost your business if it was like, hey, you need to do all this plus more now, right now, and you have to attest to it. Well, any service provider you're going to bring in for this, they're going to know who you are. They'll Google your name or search your name, and your consent order is going to pop up. The potential liability that that company could experience by engaging with your firm to deal with this consent order is astronomical. So don't be surprised if they charge you like 4 or 5 times the going rate if you can even find someone to do it, because they don't want to have to deal with federal regulators just like you don't want to have to deal with them. So keep that in mind. This stuff's going to be really expensive. All right, now let's get to the juicy part. Leadership enforcement. And this, I'll link to this video right above. This is where I think it's going to start getting real juicy. The gist of this is we saw the 20-year consent order for companies. They just came out and did a 10-year consent order against a CEO. All right. And kind of the crux of the issue there, it all started because the CEO, who was ultimately responsible, their IT department was using encryption that was cryptologically broken. Now, what CEO would reasonably know what list of encryption methods are cryptologically broken or not? They probably don't. Nonetheless, the FTC says, hey, we're going after you. And by the way, this isn't a, hey, we're just going to declare bankruptcy and then start up a new business. No, this consent order follows that guy personally. All right. It personally follows the individual for 10 years, which means I hope he really likes his job, because I can't imagine anybody is going to hire that guy. The board of directors at any company is going to go, why am I going to bring the FTC into my business snooping around with all this craziness when I can just hire somebody else who doesn't have that baggage? All right. So if you want to know about it, well, I already put the link above, but I'll put it in the description below as well. All right. Next, would cyber insurance cover these costs of 10 or 20-year consent orders? Probably not. So you'll see it right there. Cost to establish or improve security or privacy practices, or audit, reporting, or compliance costs. So the answer is, I've never seen a policy that would even remotely cover the cost of that consent order. Possibly it's going to deal with defense costs up to a certain point. I'll probably put out a video next week of a guy that tried to play nice with the FTC and spent a decade and probably, I don't know how many millions of dollars in defense costs actually went in to the fact that they just bankrupted his business. All right. Are there state level exemptions for this? Well, generally, Gramm-Leach-Bliley Act, FTC Safeguards Rules underneath that, generally preempt state laws only to the extent that they are conflicting. All right. So you're going to have to get legal counsel involved with this. It does not necessarily preempt state laws which are more protective. And there could be plenty of state laws out there that are actually more protective or more explicitly protective than the FTC Safeguards Rule. So an example of that would be if you even have a single Massachusetts resident as a client, 201 CMR 17, more stuff you got to do there. Or if you fall under New York Department of Financial Services, 23 NYCRR 500, it's got another laundry list of stuff you got to do. So you kind of see the trend here. Either way, you're going to spend more money on cybersecurity. I hate to be the guy that tells you that, but it's just what it's going to be. All right, next. This is not a one and done. Obviously, you have to keep up with changes. You're going to have to change what controls you have implemented based upon changes in technology and changes in your network and your business, etc. But the interpretations within this rule are likely going to be litigated. Now, this is an administrative ruling, and I don't want to delve into administrative law because I think it's cool because I'm a nerd, but I know it's not for everybody. But there's a couple ways that they can do it. They can do it the easy way, and I'm talking about the administrative bodies, right? These agencies like the FTC, or they can do it the hard way. So the hard way is notice and comment rulemaking. They just went through this whole process to roll out the new FTC Safeguards Rule. Now, we talked previously about, what's the term incidental mean, or regularly, if you regularly initiate wire transfers between you and a customer. What does that mean? Well, it's probably going to be litigated, which means the FTC is going to pick somebody out. Those guys are going to be the nail. The FTC is going to be the hammer, and they are going to smash that business to prove what they mean by those particular terms. So, as a guy that got a master's in cyber law, I'm just sitting here waiting for those rulings to come out because it's definitely going to happen. It's only a matter of time. I don't want it to be your business. Now, some considerations for MSPs. Please go to your clients, tell them, hey, there's this new law. Highly suggest that you go seek competent legal counsel to see if you need to comply with the FTC Safeguards Rule. Make sure you're doing that in writing, okay? Next, you are not their attorney, all right? You are not their attorney. You can make a best faith guess on how they should comply with this, but it needs to be explicitly clear to the clients, hey, I'm not your attorney, right? We can put additional controls in place, but we're not giving you legal advice. We can't guarantee you're going to comply with this. It's so new. It's going to change rapidly. And a lot of those terms or elements are really quite vague and highly up for interpretation, or they're just going to contain words like the term reasonable. That's a legal term. It's not what you or I think, or what we would even use in kind of normal parlance here. So there's so many potential hidden traps in there. If you don't have a legal background, you should not be opining on that stuff. So make it perfectly clear they should get an attorney. If you're an MSP, you are not their attorney. Next, all financial institutions are going to require something. I would also argue, hey, tell them you should go out seek legal counsel. Get a formal opinion on this, right? We're here to help. We'll help. We'll work along with legal counsel to assist you. But once again, we're not your attorney. Next, clients are going to outsource responsibility, not accountability. And that has to be made perfectly clear, okay? Do not get the runaround. If you have somebody that's not taking this seriously, if you're an MSP and you think they're just going to dump all this stuff on you, don't let that happen. I'll leave it at that. All right, next, please suggest a plan of implementation. At the next QBR, go, okay, these are the threats we're seeing. Here's the biggest bang for the buck. Roll that out to them. Make sure everything there is in writing. Document everything. All right. And when in doubt, refer to CFR Title 16, Chapter 1, Subchapter C, Part 314. All right. You found that useful? Learned something today? Like, share, comment, subscribe. The YouTube overlords will recommend another video up here. And then if you click on my beautiful face over there, you can subscribe to my channel. All right, guys, with that, stay safe.